afternoon, everyone. I want to welcome you to the City of Salina Community Relations Division Fair Housing Webinar 2021. My name is Yvonne Montoya. I am the Community Relations Supervisor.
Our next session will be on reasonable accommodations and modifications. Our speaker is Michelle Ewert, Associate Professor of Law from Washburn University. Thank you for being with us, Michelle.
So hello, everyone. Let me just get my PowerPoint pulled up here. So like Julia said, my name is Michelle Ewert. I teach at the Washburn Law Clinic. I teach the civil section, and there my students do a range of cases. We do consumer cases, public benefits cases, landlord-tenant, criminal records expungement, things like that. We represent folks who would not otherwise have access to counsel. My background is as a legal aid lawyer. I started in the Chicago area doing fair housing work with Hope Fair Housing Center. And there, the bulk of the cases that I worked on were cases involving reasonable accommodations or modifications, source of income discrimination complaints, because that was a protected class in the area, familial status cases, things like that. I then moved to Central California, where I worked for several years doing domestic violence and child abuse cases, which had, an impact on people's housing. And then from there, I moved to Baltimore and worked for several years at the Homeless Persons Representation Project, where I represented folks who were either street homeless trying to get into subsidized housing, or folks who were in subsidized housing trying to prevent eviction or termination. And there I focused on subsidized housing cases, a lot of reasonable accommodation and modification requests as well. So access to housing in general and fair housing in particular are really important to me. And so I'm so delighted that you're spending time with us this afternoon to learn more about these issues. We're going to cover several things in this session. I'm going to start with a discussion of the history of fair housing law and how that relates to the disability rights movement, so you can understand, how we got to where we are now. Then I will talk about the specific housing protections for people with disabilities. And then we'll discuss some common questions that I get related to reasonable accommodations and modifications and assistance animals in general. So before we get started, one thing I want to note is that throughout the presentation, I'm going to use terms like impairment and handicap and disability, because that is the language of the law. Those are the words that are in the statutes and regulations and case law in the fair housing context. The trend is to talk about these conditions as being difficulties. So it's not to suggest that there is anything fundamentally wrong with people who have these different conditions, but I'm going to be using the language of the law when necessary. So what are these different conditions that we're talking about that might lead to a reasonable accommodation or reasonable modification request? The U.S. Census Bureau collects data based on different types of disabilities, and currently they categorize it into 6 different categories. So hearing difficulty, which is being deaf or hard of hearing; vision difficulty, which means that either someone is blind or has a hard time seeing even if they are wearing glasses; cognitive difficulty, so people who have trouble remembering things, concentrating, making decisions because of some other problem or condition; people who have ambulatory difficulties, so folks who have a hard time walking or climbing stairs; self-care difficulties, so having difficulty doing, daily tasks to take care of yourself, hygiene activities, things like that; and then independent living difficulties, so having a hard time taking care of errands outside the house on your own because of some condition that you're dealing with. And these, as you can imagine, these different conditions impact access to housing in many different ways. And are really prevalent. What you're looking at now is a chart prepared by the Census Bureau that identifies how many people in the United States, broken down by age and gender, have these different difficulties. And many people would have, multiple difficulties. And this implicates housing for several reasons. First of all, there's a really strong correlation between serious disability and income. So people who have very serious disabilities are likely to have a hard time securing safe, affordable housing. Some of you might be aware that currently the maximum amount of supplemental security income for an individual is $794. So for people who rely on SSI as their only source of income, they have less than $800 a month to live on. And in Salina in the county, the fair market rent for an efficiency is $546, and for a one bedroom is $610. So you can see, for someone who's dependent on SSI, trying to find a place they can live without a subsidy is very difficult. And in fact, HUD has issued some reports on this issue. There was a study that found, and I'm quoting from HUD now, renter households with non-elderly disabled members are more likely than non-disabled households to have very low income, experience worst case housing needs, pay more than 50% of their income on rent, and live in inadequate or overcrowded housing. So the way that disability interacts with income can create barriers to housing. But even with people with disabilities can obtain housing, they might need accommodations or modifications to use it. And this is where fair housing comes in. So Teresa gave a nice overview of the history of fair housing. I'm going to talk a little bit more specifically about sort of how the civil rights movement played in and how that evolved over time. So the civil rights movement focused on a range of issues. So things like employment, education, voting rights, and housing. And the reason housing was such a cornerstone was that housing discrimination was really entrenched in the United States. This started in the early 1900s with something called exclusionary zoning, where communities passed local ordinances that said that people of certain backgrounds, typically Black people, people of Asian descent, could not live in certain areas. And that was the law. But in 1917, the Supreme Court struck that down, said that's unconstitutional. The government cannot participate in discrimination in that way. And so then what happened was we saw, instead of the cities enforcing segregation through city ordinances, we saw people getting together and creating these restrictive covenants or contracts that said you could not rent or sell to people of certain backgrounds. And again, that was Black people, Asian people, and Jewish people also. These were racially restrictive covenants. And in 1948, the Supreme Court said you can't use the court system to enforce these illegal or to enforce these discriminatory covenants. But people were still enforcing them among themselves. They just weren't going to court. And so what happened was, by the time we got to the mid-1960s, which is the height of the civil rights movement for Black people, segregation and housing discrimination was really entrenched. And there had been multiple efforts to pass fair housing legislation. This is a bill that would come up year after year after year, and Congress just could not get it over the finish line. Not enough Congress people supported it. Well, as Teresa said, then in 1968, following the assassination of Dr. King, the protests around the country just erupted, and finally Congress was forced to take action. And so what happened was, when the Fair Housing Act was passed, it was responding to the discrimination that was seen as most pressing at the time and most prevalent. And so race, color, religion, and national origin were the protected classes, because Black people, Asian people, and Jewish people were the most frequent subjects of discriminatory conduct. Well, then what we had was the growth of the women's rights movement. So in the late 60s and early 70s, there was the push for the Equal Rights Amendment. Women were wanting to be treated equally in their jobs. They wanted to be able to access credit on their own without a husband or brother or father co-signing with them. And they needed housing protection. So in 1974, sex was added at the federal level as a protected class. Well, then we saw the disability rights movement gaining momentum. And so finally in 1988, Congress amended the statute for the final time and added what it called handicap and familial status as protected classes. And so the addition of disability rights to the Fair Housing Act was in direct response to the advocacy that was happening around the country to promote greater rights for folks with disabilities. Because what had happened was, in the 1800s and early 1900s, a lot of people who had either mental health issues or physical health issues had been institutionalized, put in hospitals or sanatoriums or other residential facilities, so separate from the rest of the community. It meant that people were isolated from their loved ones and not integrated into community life. And so by the mid-1900s, there was a big push for community-based programming. And this addition to the Fair Housing Act helped promote that. What you're looking at now is a picture of one of the plaintiffs in one of the most famous disability rights cases. Her name is Lois Curtis. She's there in the center, just to the left of President Barack Obama. And she was one of a couple of people who sued the state of Georgia because they had not been returned to community-based programming. Lois Curtis was diagnosed with intellectual disabilities and schizophrenia, and had voluntarily admitted herself to a psychiatric unit for treatment in 1992. She was stabilized in 1993, but the state kept her there in the psychiatric hospital for 3 more years until 1996, when it finally released her into a community-based program. And this was an ADA case, but the language that the Supreme Court used is helpful in understanding why fair housing protections for people with disabilities were necessary. The Supreme Court said, confinement in an institution severely diminishes the everyday life activities of individuals, including family relations, social contacts, work options, economic independence, educational advancement, and cultural enrichment. So if our goal is for folks with disabilities to live in the community so they can participate in all these aspects of community life, we need to have housing that is safe and accessible and that accommodates their conditions. So as Teresa mentioned, there are a range of behaviors that are unlawful under the Fair Housing Act. So, she talked about steering, false statements about the availability of units, discriminatory advertising, discriminatory terms or disparate terms, things like that. So the piece that is relevant here as it relates to disability is the refusal to accommodate disabilities in some way. And I want to spend a little bit of time walking through the statute so you understand what the law is before we start talking about, common questions that you might have. So first of all, who does the Fair Housing Act protect as it relates to disability? It's important to understand that there are a whole range of people who are covered. And so it relates to the actual buyer or renter themselves, if that person has a disability. It relates to household members of the buyer or the renter, and anyone associated with that buyer or renter. And so when you're thinking about accommodation requests, you think not just about the need of the person with whom you have a contract, but other people in their household or other people in their life who might be coming to their household. Second, how does the Fair Housing Act define handicap? And again, that's the language in the statute. So that's the word that I'm using, even though that is not sort of the preferred term for folks in the disability rights community. The Fair Housing Act defines handicap to include several things. First of all, a physical or a mental impairment that substantially limits one or more of the person's major life activities. And we're going to actually unpack all of those different terms. So having a condition that impacts your ability to engage in major life activities. Second, a record of having such an impairment. So someone who in the past had an impairment that limited their activities. So someone who maybe now does not, but in the past did. And then third, being regarded as having an impairment. And that plays out several different ways. It could be that the person does have a physical or mental impairment, but it does not actually substantially limit one of their major life activities. It could be that they have a physical or mental impairment that affects their major life activities, not because of the impairment itself, but because of how other people perceive the impairment. Or it could be that they have been misclassified as having a disability. And I would just note that the statute, as you see on the screen, specifically does not include current illegal use or addiction to a controlled substance as being an impairment. So what this means is if someone is in recovery, so if they're a recovering alcoholic or recovering drug addict, the fact that they're in recovery means that they have a covered disability. But if they are currently actively using the illegal drugs, then that does not protect them. So I said we wanted to talk a little bit about some of these terms. So let's take a look at some of the regulations, because HUD has, in a helpful way, explained some of these important terms. So What you're looking at now is HUD's definition of what a physical or mental impairment is. And HUD gives examples. So it includes specific diseases or conditions such as speech or vision or hearing impairments, conditions like autism or epilepsy, diagnoses like having an HIV infection, intellectual disabilities, emotional illnesses, or recovering from drug addiction or alcoholism. So these are all examples of what qualifies as a physical or a mental impairment. Now, I would note, this is not an exhaustive list. So there are many, many other conditions that people might have, many difficulties that are in fact physical or mental impairments that are not on this list. This is just a set of examples. So then HUD goes on to describe what major life activities are. And they define that as functions such as caring for oneself. So things like bathing, toileting, stuff like that, performing manual tasks. So things like preparing food, cleaning, walking, seeing, hearing, speaking, breathing, learning, working. So again, this is not an exhaustive list, but these are examples of major life activities where if someone's condition or difficulty interferes with that, they would likely be entitled to an accommodation. So there are two obligations that housing providers have as it relates to accommodations. There's the reasonable accommodation in policies and procedures, and then reasonable modifications. And so what we're looking at here is the statutory description of illegal discrimination as it relates to a modification request. And that would be a refusal to allow a person with a disability to make a physical modification to the premises if it's necessary for them to utilize the premises. We're going to talk later about who pays for modifications, but let's just talk first about what examples of modifications would be. So using the chat box, why don't we generate a list of examples of modifications that someone might request? What are modifications that you might have seen in your complexes, or that you could imagine someone with a disability requesting? Okay. People coming with some excellent examples here. So someone says wheelchair access, someone says handicap ramp. So absolutely. So if someone is using a mobility aid, a cane or a walker or a wheelchair, stairs are going to be hard to navigate. And so a ramp would be necessary. Someone says handrails, some handrails in the bathroom or showers specifically. So it could be that someone perhaps is a little bit unsteady. And so they need things to grab onto as they're walking along a hallway or up some stairs or in the shower where it's very slippery. Absolutely. Someone says laundry access. So it could be that the structure of the machines is such that, people's conditions make it difficult for them to use. Someone says lighting. And so it could be that people have, visual impairments. And so, need a certain level of lighting. Someone says doorbell or alert of a visitor. Absolutely. So for someone who is deaf or hard of hearing, an audio doorbell might not be useful to them. They might need a doorbell that's linked to a light or something that flashes so they know that the doorbell is ringing. Other examples might be replacing doorknobs with levers. So instead of having to, grab and twist a knob, which can be very difficult for people with arthritis or something, having a lever that they can just push down. Those are all excellent examples of accommodations that someone might need. So then we have reasonable accommodations to policies, rules, and procedures. So discriminatory conduct under the statute would be a refusal to make reasonable accommodations in rules, policies, practices, or services when those accommodations are necessary for a person with disabilities to utilize the housing. So again, using the chat box, what would be examples of accommodations that a tenant might ask for, either things that you have seen in your own complexes or things that someone might need to accommodate a disability? What do you all think? Okay, so someone says the application process. It could be that if you require that someone complete an application online, that makes it difficult for folks who have vision impairments to apply. And so you might need to allow phone applications or something as an accommodation. There are a range of things. So let's say, for example, that you require that rent be due on the first of the month. Very common clause. But let's say someone gets SSDI or SSI is their only source of income, which historically has come on the third. It might be that you need to accommodate your tenant and have their rent due date be the fifth instead of the third. I'm sorry, the fifth instead of the first, so that their disability benefits will have hit their account before rent is due. It could be that you have a sort of first come, first served policy regarding parking spots, but that someone with a mobility issue needs a designated spot closer to the entrance of the building so they can get in safely. That would be an example of an accommodation to a parking policy. It could be that someone makes a request to be transferred to a first floor unit because they can't deal with stairs or something. And so you allow them to move as an accommodation to a disability that they've developed. It could be that historically you've asked tenants to pay rent in person, but you have a tenant who maybe because of a mental health issue gets very anxious when they leave their unit. And so they would rather pay their rent by mail or something. These are all examples of accommodations that you might make to allow someone with a disability to use the housing. And we're going to talk about, pet policies and how that actually is not relevant for assistance animals. You might, waive a guest fee for a live-in aid, things like that. And so sort of the range of accommodations that someone might need is really as broad as the range of needs that people have. So these are the statutes and regulations at the federal level. I would just note that there are also fair housing protections at the state level, and I think that Teresa mentioned this. In Kansas, the act is called the Kansas Act Against Discrimination, and I would note that it tracks pretty closely with the federal Civil Rights Act in terms of protected classes, except that Kansas adds ancestry as a protected class. So, national origin deals with, where a person is from. Ancestry deals with, where their ancestors are from. And so that's an additional protected class in Kansas. I would also note that we looked at some of the definitions and the regulations for the Fair Housing Act. The Kansas Act Against Discrimination has some clarification on how it defines disability, which is the phrase it uses instead of handicap. It clarifies that an impairment that is episodic, so occurs, repeatedly, or is in remission, is a disability. If either of those things would be an impairment if they limited a life activity when they were active. And so Kansas does a nice job of explaining a little bit more what a disability means. And I would just say, this training is really important. Teresa talked about the number of, cases that are filed annually and sort of the prevalence of these complaints. As of January 2020, according to HUD, almost 60% of all fair housing complaints involved failure to reasonably accommodate a disability or some sort of disability excess case. And so this issue of accommodations and modifications is really critical. And like Teresa said, a lot of the time when there are complaints filed, it's that the housing provider might not understand the law. And so is not trying to, do harm to the tenant or the applicant, but might not understand what their responsibilities are. And so I hope that you leave the training feeling like you understand a whole lot better how you can run your programs so they're in compliance. So let's just talk briefly about the process for requesting and processing a reasonable accommodation or modification. So the first step is that the tenant makes the request. Now, this request doesn't have to be in writing. An oral request is sufficient to trigger the process. As an attorney, I encourage my clients to put requests in writing so there's a clear record of what was requested and everyone's on the same page about what was communicated, but it's not required. An oral request is sufficient. I know that many housing providers have a form that they have created for tenants to use to request accommodations or modifications. That's fine, but you cannot require that the tenant uses that form. There's no specific form that the law mandates must be used to request an accommodation. The second thing about the request is it doesn't have to be made by the tenant. It could be made by the tenant, of course, but it could also be made by a family member or a social worker or another representative acting on the tenant's behalf. And then finally, there's no magic language that has to be in the request to put the landlord on notice. And we're going to talk in more detail about the kind of documentation that landlords can request, but there is no magic language for the actual request. So once the request has been made, if the landlord doesn't immediately approve the accommodation or modification request, the landlord and the tenant engage in what's called the interactive process. And this is what HUD mandates landlords do to get information about why the accommodation is necessary and how that accommodation can be made to best meet the tenant's needs. And that interactive process, can go on for a short period of time or longer period of time, depending on sort of what information needs to be discussed. And then at the end of that interactive process, hopefully, the landlord is able to grant the request. If not, then the landlord denies the request. So when can a landlord properly deny a request? What do you all think? There's several large categories when someone can deny a request. Or do they have to give the tenant everything the tenant wants? What do you think? You can type this in the chat. Yes, undue hardship. We're going to talk about that. What else? Yes, not reasonable or overburdensome from a cost standpoint. Yeah. So there are several situations in which a landlord can properly deny a request. The first is if it's not actually made on behalf of a person with a disability. And this might seem strange for you, but the person making the request or benefiting from the request does have to establish that they are a covered person, that they are a household member or someone connected to their household needs that particular accommodation or modification. Second, there has to be a disability-related need for the accommodation. There has to be a relationship between what is being asked and the disabling condition. And in law, the word we use is nexus. So if there is not a nexus or a connection between what the tenant is asking and what the modification is and their disability, the landlord can properly deny that. And then the third is what a couple people have identified, is if the accommodation is just not reasonable. And that plays out in two different ways. It could be that it, as Nick says, imposes an undue financial or administrative burden. So if it's just unreasonably expensive, or if it creates an administrative burden that the provider just can't bear. So an example might be, let's say there's a multifamily development and tenants throw out their trash in a large dumpster, where you have to either lift up the lid or, pull aside a window to get into the large dumpster. And maybe someone has some issues, gripping, some strength challenges, some mobility issues, and they can't get out there to put their trash in the dumpster. And so they ask that the maintenance staff come every day and take out their trash for them. Now, if it's a very large, very many, tenants and a lot of maintenance staff, maybe, there's staff who can do that. But for a lot of complexes, that would be a real burden, right? To have someone's time every day designated to go and pick up trash and take it out. And so the request that the person have, basically personal trash service is probably not reasonable. But in the process of engaging in that interactive process, hopefully the tenant and the landlord would arrive at an agreement where perhaps there would be like a smaller bin in the hall or something where people could put their trash if they could not get out to the large dumpster. So that would be an example of an undue administrative burden. The second way an accommodation might not be reasonable is if it would fundamentally alter the provider's operations. So let's say that because of someone's difficulties, they can't get to the grocery store easily. And so they ask the landlord to drive them to the grocery store, wait while they do their shopping, and then drive them back to the complex. Now, unless the landlord is running some sort of shuttle service for all the tenants, that is a very, very big departure from what most landlords, provide as part of their, regular services. And so that accommodation that's requested would not be reasonable because it would fundamentally alter the landlord's services. And so those are examples of where a provider, could properly deny a request. And there's a question in the chat about service. We're going to spend a lot of time talking about that. So hold that question. A couple of things I would just note. Failure to respond to a reasonable accommodation or reasonable modification request within a reasonable period of time is treated like a constructive denial. So landlords can't just sit on requests and do nothing. They have to engage in this process, this interactive process, and then issue a decision. And courts for about 20 years, actually more, have found that failure to respond or failure to issue a decision is a constructive denial, and that then tenants can proceed with litigation under the Fair Housing Act. And there's a 2020 HUD memo that I'm going to actually share at the end of the presentation that says that it's best practice for housing providers to respond within 10 days if they receive documentation regarding a request for an assistance animal, which again, we're going to discuss more later. The only other thing I would note about this interactive process and when denial is appropriate is the landlord, if it's a case involving a modification, the landlord can require that the tenant obtains the necessary permits before the modification is completed, and that the work is done in a workmanlike manner. They just can't require that a specific contractor does the work. Okay, so that's sort of an overview of what the law requires. Let's now talk about some specific questions that you might have. So the first question is, what kind of documentation can a landlord ask for to support a reasonable accommodation or reasonable modification request? And this is an area where a lot of people get tripped up. So if the disability is apparent and the need for an accommodation or modification is apparent, the landlord cannot ask for additional documentation. However, if either the disability is unclear or what the need is for an accommodation is unclear, then the landlord can ask for documentation. And that would include several things. First, that there is a disability, not what the disability is, not how severe it is, but just there is a disability. Second, what the person's need is. So, what the needed accommodation is or modification is, why that is necessary, and then how the requested accommodation or modification would meet that need. So it's actually pretty narrow what you can ask for. Now, when I'm doing these accommodation or modification requests, I often, with my clients, we'll talk about, how much they want to disclose to their landlord. And we will often, or sometimes at least, not necessarily often, but sometimes include more detail than is legally necessary, just so the landlord understands more context. But again, all that is required is that the landlord has evidence that the person has a disability, not what it is, but that there is a disability, how the disability affects them, and what the requested accommodation is that would meet that need. So any questions about that? Any questions about what kind of documentation? Okay, someone says, can a landlord get clarification from somewhere at federal, state, or local level indicating examples of reasonable versus unreasonable accommodations, or a hotline? Teresa, you might have information about that as well. Like she had said, you can always contact the State Fair Housing Agency, which is the Human Rights Commission. You can also contact HUD to get some advice. HCCI also does advice. I'm going to be sending, or I'm going to be providing you with several memos at the end that HUD and DOJ have issued that I think will be very helpful, that walk through examples of reasonable and unreasonable accommodations and modifications. So I'm going to share that at the end of the presentation. And I've also sent that to Julia to include with the packet to participants. And so you'll be able to look through that. I think that will be really helpful. Okay, so let's go on then. So second common question that I get: what animals are allowed as assistance animals under the Fair Housing Act? This is where a lot of people get tripped up, because the Fair Housing Act is vastly, vastly different than the Americans with Disabilities Act. So under the Fair Housing Act, and again, you're going to get information about this in the form of HUD memos and DOJ memos. HUD identifies two different categories of animals that qualify as assistance animals. The first would be service animals. The second would be support animals. So service animals are animals that perform a particular function, perform a particular service for someone. So examples would be, a dog that barks if the doorbell rings. So let's say someone is hard of hearing and can't hear the doorbell or the smoke alarm. A dog that barks or comes over and gets their attention, that dog is performing a service. It could be that someone has difficulty gripping items, maybe has limited strength in their hands, limited mobility of their hands. They might need a monkey that will help open, doors, open drawers, pick up items, hand them items, things like that. Those are examples of service animals. Support animals are a little different. Those are animals that provide companionship and help people with emotional difficulties to sort of, get by and cope. And so it could be that, just the companionship of the animal in the home helps manage, the disability. It could be that the structure of, getting up and scooping the litter box and having to feed the cat or, take the dog out for a walk are things that help someone, say with depression, sort of, get out and stick to a routine. So it could be that that emotional support animal helps cope with the disability in that way. So like I said, under the Fair Housing Act, both support animals and service animals are covered assistance animals. And I'm going to actually quote from one of the HUD memos that you're going to get in your packet. This is a 2013 memo. I think it was actually a joint HUD and DOJ memo. Might be just HUD. But what it says is, and this is directly from the memo, an assistance animal is not a pet. It is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. Assistance animals perform many disability-related functions, including but not limited to guiding individuals who are blind or have low vision, alerting individuals who are deaf or hard of hearing to sounds, providing protection or rescue assistance, pulling a wheelchair, fetching items, alerting persons to impending seizures, or providing emotional support to persons with disabilities who have a disability-related need for such support. For purposes of reasonable accommodation requests, neither the Fair Housing Act nor Section 504 require an assistance animal to be individually trained or certified. While dogs are the most common type of assistance animal, other animals can also be assistance animals. So what you see here with this HUD memo is the requirements under the Fair Housing Act are very different than under the ADA. So first of all, the Fair Housing Act does not require that the animal be specifically trained and certified. This is different than the ADA, where certification is required. You just need to know that that particular animal provides the particular assistance that that tenant needs. Second, under the Fair Housing Act, an assistance animal does not have to be a dog. And again, that's different than the ADA, where only dogs are currently recognized as assistance animals. And in one of the memos that you're going to see from HUD, there's actually a discussion about what are common assistance animals, what are more unique assistance animals. And HUD, excuse me, HUD identifies animals like dogs, cats, small birds, rabbits, hamsters, gerbils, other rodents, fish, turtles, and other small domesticated animals as common assistance animals, where if the tenant makes a request for one of those, as long as you can establish the need, you don't have to go into, great analysis about whether that particular animal is appropriate, because those are common animals. However, the memo talks then about unique animals, where you might want to get a little bit more clarification. And so it says, if the individual is requesting to keep a unique type of animal that is not commonly kept in households as described above, excuse me, then the requester, so the tenant in this case, has a substantial burden of demonstrating a disability-related therapeutic need for the specific animal or the specific type of animal. And the examples that HUD gives include reptiles other than turtles, barnyard animals, monkeys, kangaroos, and other non-domesticated animals. And so if the tenant asks for one of those types of animals to be, the assistance animal, you might, you would be allowed to do a bit more, questioning to make sure that that particular animal actually is necessary to meet the particular need. Something that I sometimes hear is, well, what about pit bulls? What about German shepherds? What about, bully breeds? So the Fair Housing Act is very clear. You cannot make assumptions or restrictions based on breed. And in fact, the HUD memo you're going to see says breed, size, and weight limitations may not be applied to an assistance animal. And so you might have a policy, of only dogs in your, units and no dog over 25 pounds. That's a pretty common restriction that I have seen in leases. However, if someone has a need for another type of animal as their assistance animal, or for a larger dog, as long as that particular dog is reasonable, you would have to accommodate that. And so this is a very, very animal specific analysis. And so you would want to know, for those of you who might be concerned, well, what if the animal, might harm other tenants or something? If the particular animal poses a direct threat, so that particular animal has a history of aggression or of biting or of destruction, then that animal would not be reasonable, is a reasonable accommodation. But you can't say, no, German shepherds or no dogs over 35 pounds or something. You have to look at a particular animal to see if that particular animal would be a threat. Someone says, how does that apply when there's a law preventing a certain type in the community? And so what we often see in these cases is the tenant would do not just an accommodation request to the landlord, but also an accommodation request to the city or the county that has the restrictive ordinance. And some of those have been found to be unlawful if the city or the county did not allow flexibility and allow the accommodation. It could be that, you're in a city and the ordinance says that you can't have, horses or something, but maybe someone has, a small, like miniature horse that's their assistance animal. If it's reasonable for that particular miniature horse to be the assistance animal, the city would have to make that accommodation. And so it's best, if you're the landlord, to go ahead and allow the accommodation. And then, just the tenant would need to also then get an accommodation from the city as well. Does that answer the question? I hope so. Okay, so those, okay, great. I see a yes there. So that gets at what types of animals are allowed as assistance animals under the FHA. And again, you're going to get a copy of the memo that addresses this in a whole lot more detail. So the next question I often get relating to assistance animals is, well, can I charge a pet fee or a pet deposit or a pet rent? The answer is no, 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 no. And the reason for that is because an assistance animal is not a pet. An assistance animal is a tool that allows a person with a disability to utilize their housing. So it is illegal to charge a monthly fee for an assistance animal. It is illegal to charge a security deposit for an assistance animal. Now, if that animal damages the unit, you can treat that damage just like you would as if the tenant themselves did it, or a household member or a guest. You can withhold the security deposit up to the amount that you need to make the repairs. And you can sue the tenant, after the fact for the damages, but you cannot in advance charge a pet fee or a deposit for an assistance animal. So any questions about that? That's one that I see a lot. Okay, so a third question, a fourth question that I see would be related to modifications, and that's who has to pay for a reasonable modification. Some are not too expensive, not a big deal. Others can be very expensive. Excuse me. So generally, the tenant themselves is responsible to pay for the modification. Now, you as the landlord might choose to do so out of the goodness of your heart, or because you think it's actually a good business model to keep tenants happy, or because you want to actually make those modifications throughout the building. But generally, the tenant is responsible. The exception is if it's a federally subsidized unit. In federally subsidized housing, the modification is the obligation of the provider unless it would impose an undue financial or administrative burden, unless it would require a fundamental alteration of the program, or unless there's an alternative way to accommodate the tenant. And in that case, so the subsidized housing provider would pay unless the modification is unreasonable for some reason. The question is, are they responsible only for the cost of material or material and labor? So if the tenant is responsible for the modification, the tenant pays for the cost of the installation, which would include both the materials and the labor. If it's a subsidized unit, and so the landlord is responsible, they would pay for the materials and the labor. And like I said before, the landlord cannot require that a particular contractor is used. They can only require that the proper permits are obtained and that the work is done in a workmanlike manner. Now, one thing I would note is sometimes a tenant might propose a modification, and it's reasonable, it complies with building code, but the landlord would like a slightly nicer, or what it perceives as a slightly better modification to be made, maybe a prettier one, more aesthetically pleasing or something. If the landlord is requiring the tenant to do more than what is sort of the minimum by law, the landlord is then responsible for the difference in costs between the basic modification and the sort of souped up, prettier modification. And then the other thing I note about modifications is for buildings that are newer, who are built post 1991, a lot of the modifications might already be in place or might already be sort of primed. And so in 1991, the Fair Housing Act says that for covered multifamily dwellings built for first occupancy after March 13, 1991, they already have to be designed and constructed to meet certain minimum accessibility requirements or adaptability standards. So they have to have, accessible common use areas. Doors have to be wide enough to get mobility aids through, like wheelchairs and walkers. There have to be accessible light switches and outlets and thermostats. And so for newer developments, a lot of these accommodations or modifications are already in place. But for older developments, you might have tenants who need some of these added in so they can use the space. And so for, pre-1991 buildings, landlords must allow modifications that would bring the building into compliance with the Fair Housing Act for post-1991 development. So any questions about that? Okay, so then the final question I want to cover is, what obligation does the tenant have to restore the unit after a modification has been made? So after the tenant moves out, what happens? They might have made some adjustments to the bathroom. They might have made some adjustments to the kitchen, things like that. So the landlord can ask the tenant to restore the interior of the unit following modification if it is reasonable to do so. So a couple important things here. The interior only. If there were modifications made to the common areas or to the exterior of the building, the tenant is not responsible for undoing those. The landlord would just leave those in place because other people will benefit from them, right? But there's this issue of is it reasonable to ask the tenant to undo the modifications to the interior of the unit? So let's say someone was in a pre-1991 unit and needed to expand the doorway so they could get a wheelchair through. It'd be very unreasonable for the landlord to ask the tenant to tear down the wall, put a new wall in and put, a smaller door frame, because future tenants, their use and enjoyment is not impacted by having a wider doorway. They actually might appreciate that because they can get furniture through more easily and stuff. And so that's an example where the tenant would not be required to restore the modification because it would not be reasonable to require them to do so. Okay. Any other questions about that? All right. Seeing none. So I mentioned throughout the presentation that there are a number of memos and joint statements that I think will be really helpful to you as you're learning more about your rights and obligations under the Fair Housing Act. And so there are four. The first two are joint HUD and DOJ statements that relate to reasonable accommodations and reasonable modifications. And those are from the 2000s. Then I have two additional notices that are specific to HUD that HUD issued in 2013 and 2020 that talk about assistance animals. And those will be made available to you as part of the packet. I would encourage you to read through them. They're not very long. I think the longest is like 27 pages and the shorter ones are, a little bit shorter. But they have really excellent information about what is allowed and what is not allowed. Examples of appropriate landlord behavior and behavior that would violate the Fair Housing Act. And so I would recommend that you, read those, have those accessible to your staff because they will answer a lot of questions that you would have. Then the last, I'm putting my contact information up here on the screen. I'm a professor at Washburn. We're in school, during the school year, but I'm here, 12 months a year. And so I'm happy to direct people to resources that might be helpful. I am happy to do trainings also on fair housing issues for particular providers. That's something that I did a lot in my prior life. I'm happy to do that here now. And so I hope that you will reach out if you have additional questions. Thank you so much for your attention. I appreciate all of you trying to, sorry, I want to stop screen sharing here. My thing is being uncooperative. I want to thank you for coming. These are such important issues. And our goal is obviously to, limit the number of cases that need to be filed, the number of complaints, because tenants understand their rights, landlords understand their obligations, and people are working together well so that folks with disabilities can use their housing. So thank you so much.